Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is William Mahan, who I'll call Bill. And Bill has his law office in San Jose, California. He is a lawyer. He is of counsel to Gates, Eisenhart, Dawson, a law firm here in the area. He's been practicing law for about 32 years?
32,
so?
yeah.
And he has a master's in taxation degree from Golden Gate University, and he has his law degree JD from Santa Clara University. His practice focuses on estate planning and probate and business planning. And I've known Bill for a number of years. He's been a guest before on this show, and I feel that he has a lot to contribute, so I'm glad to have him here. So Bill, thanks for joining me today.
Thank you.
So today we're going to be talking about tax and financial considerations of title. So this is how you hold ownership to property. And so this is a legal topic. There are courses related to this. We're not going to cover everything in a 28-minute interview. And so I hope you'll be realistic in your expectations. But also, we hope we can bring up some issues for you to think about and hopefully discuss with your own attorney and a tax advisor. Okay, Phil, so thanks again for joining me today. Well, what are some of the... there is one other thing. We're in California. So in California, for example, we have community property. That's sort of a special animal, and also we interpret it in a special way in California. And so this varies from state to state. I have to let you know this also because things can vary from place to place. It's another good reason for going and seeing an attorney in your community. Okay, now, what are some alternative forms that we can hold title to property?
All right, well, there are many forms, and it does vary from state to state, but some of the major ways in California is separate property, which is usually individual person or individuals who own an interest in the property, so they own the title as separate property. You'll see that as sole and separate property. An unmarried person as their sole and separate property, different ways, but that's what that means. And then there's tenants in common, which is where people have a group interest in a piece of real estate. They have undivided interest in the property.
So you may own, for example, a 1/3 interest
in the whole property.
In the whole thing.
Right.
And some people may have varying interests for tenants in common. So you may have one person that owns 10%, one owns 50%,
right.
What have you. Okay.
Right. Then we have a really common way that property is held in California, which is joint tenancy. Usually it's worded joint tenancy with right of survivorship. And what that means is that if multiple people, it would be multiple people own the property. If one of them dies, then the other owners succeed to their ownership interest in the property just by virtue of surviving. We have a newer form of ownership in California called community property with right of survivorship. You mentioned in your opening remarks that community property is something we have in California. It relates to married couples, and now it relates to registered domestic partners in California.
Right.
So it's a special type of ownership for those people. So you can own property as community property with a spouse, and then we have community property with right of survivorship, which is the same as joint tenancy with right of survivorship, except the ownership interest is community property, but the survivorship would still apply if you're the surviving person. We have some other fairly common ways of holding title, not necessarily to real estate, but to other assets like accounts. Bank accounts can be held in these same ways, community property, joint tenancy. We also have something called a Totten trust, which is a way of owning an account in trust for somebody else. We have payable on death accounts, which are accounts that are in a person's name, but at their death there's a beneficiary or beneficiaries who are designated. And then the other major category of ownership would be in some kind of an entity where rather than the individuals owning it, it's owned by a corporation or a limited liability company or even a trust.
Right, okay. So one concern that people have sometimes is trying to bypass probate, which may or may not be a good idea. But maybe you can talk a little bit about that and some of the ways that people go about trying to avoid probate.
Yeah, well, I think avoiding probate is generally a good idea. It's just how you go about doing it that may not be a good idea. There may be some exceptions to the general rule, but most of the time it's a good idea to try to avoid probate. But people will try to do that without doing estate planning, and they'll try to do that by how they hold title to the asset. So again, we have these right of survivorship ownerships, the joint tenancy or the community property with right of survivorship. And what people will do is add another person's name to title in that way, with the idea being that if they die, when they die, the property will pass to the person they want it to pass to, and it won't go through probate because of the right of survivorship. Well, it's true, it won't, but we'll talk a little bit later about what's wrong with that and why it isn't necessarily a good plan. And also these other things I talked about, the taught trust and the payable on death account idea is a way of passing to a beneficiary. Other assets like retirement accounts have beneficiary designations, life insurance has beneficiary designations, annuities. So these kinds of things, because they have beneficiary designations, will pass outside of probate to the designated beneficiary.
Okay. Maybe before we go on, maybe we should talk just really briefly about, what is probate and why do people think in many cases that they want to avoid it, or why do we think it might be a good idea in some cases and maybe not so a good idea in others?
Right. Well, probate is the procedure after a person dies. Most cases it's after they die, but things like conservatorships are also probate cases. But we're talking here about decedents' estates.
Yes.
So after a person dies, if they have an estate that hasn't been taken care of otherwise, then it has to pass on to the next group of beneficiaries through a process, and that process is called probate. So you go to the superior court in the county where the person lived the time of their death, and you file a case and process it through the court. Now, what's difficult about it is it takes usually in the neighborhood of a year to go through a probate, and there are probate fees that are paid primarily to the attorney, but also to the person who administers the estate.
So this is like a statutory schedule. There's a list of
Right.
fees,
Yeah, the
percentages
fees,
of the assets.
most of the time are set statutorily, and they're fairly expensive. They're a percentage of the gross estate that goes through probate, and so it could be 3 or 4% of the total estate that you're going to have to lose in the process in order to get it processed through. So there's the expense, but the expense comes out of the estate itself. I think the time lost and the court, delays and sometimes having to go through court proceedings to get things done, that makes it unpleasant. And then if things get more complicated, like let's say only as complicated as having to sell a piece of real estate, there are additional probate fees. They're called extraordinary fees, and that are charged on top of the statutory fees. So it can get quite expensive and take some time to complete. When it's not a good idea, so most of the time it's a good idea to avoid it, but when it's not a good idea is when you have something that's really contentious, because no matter what happens in a really contentious situation, maybe because of family reasons or ownership issues with property or whatever, you're going to end up probably in a court proceeding anyway. So there are maybe some times, and in my 32 years, I've seen some instances where you're probably just as well off to go through the probate process. It's already very structured, and the proceedings are relatively easy compared to litigation. And so maybe a probate in a case like that isn't the worst thing, because you're probably going to be in court no matter what happens.
Okay. What do you think the biggest mistake that people tend to make related to title?
Well, I guess that depends on the kind of mistake you're talking about.
Yeah.
I see a lot of mistakes that are just made in the way they're worded.
Oh, yeah, okay.
And so oftentimes people will try to do this on their own. You see all kinds of deeds. Some of them are just handwritten, and they just get the wording wrong, and it gets to be very confusing. But also I've seen deeds prepared by title companies that are not accurate either, or they're at least ambiguous in some way. So there's drafting errors. You need to actually be pretty knowledgeable to properly draft conveyances. So it's not something, again, to try to do on your own. It's a risky thing to do. But the other kinds of mistakes I see are just people not really understanding what it is they've done. So they'll add somebody to title, like a joint tenant, maybe a child. Maybe they'll have 3 children. They'll add one of the children with the idea being that that child will do the right thing later and give it to the others. And it does.
You can always count on that, can't you?
Well, you can, but not always, And so things don't always turn out the way people expect them to.
Uh-huh.
And one of the big problems, again, I'll touch on a little more later, is that people don't necessarily die in the order you think they're going to die in. So you don't necessarily accomplish what you thought you were accomplishing by adding people in ways like that.
Mm-hmm.
I also see people who do, in the process of doing something like refinancing, in order to qualify for financing, they'll add people. It might be a spouse, it might be a child, it might be a partner, but they add people to title for purposes of getting the refinancing done, and the lenders require these people be on title if they're going to be counted for refinancing purposes. But that leads to other problems that aren't intentional or not intended things to happen. Like you do have now somebody who has an interest in your property, and that maybe wasn't the intention, or at least not to the extent that they're going to end up having an interest.
Yeah.
So those kinds of things happen.
So people think that they're doing something, oh, it's just a requirement for this financing or whatever, but there may be other implications. I mean, there could even be, for example, a change of ownership, property tax reassessment or something like that.
Yeah, I'll talk about that in a minute too.
Yeah.
But yeah, all kinds of unintended consequences because you don't really fully understand the scope of what you're doing. Gifting is another issue that can occur without it being the intention.
Right.
So it's sort of hard to imagine an unintentional gift, but after the fact, if the person who did the retitling has passed away and somebody else's name appears on title, how do you explain that?
Yeah. And we mentioned this thing again related to the refinancing and so forth. So sometimes the intention is, well, for example, quite often they ask that property be taken out of the trust, if you have a revocable trust,
Right.
for when you're doing the refinancing. And then people don't get around to putting it back.
Right. The lenders will require the property be taken out of a trust or maybe out of an entity, where you had it for limited liability purposes.
Yeah,
There are all different reasons that these things are done. But in order to get financing, you have to do something different, and then you don't put it back or you don't fix it.
Yeah.
So the people who are lending the money are requiring you to do it, but they're not necessarily going to make sure you put it back.
That's for sure. Okay. Well, a lot of times, again, you mentioned the thing about putting a child's name on or what have you, or this business of just in general holding property as joint tenants with children. You see this quite a bit with bank accounts with elder parents now.
Right.
They'll add a child and so forth because, well, they want somebody to be able to write the check, and they don't know any alternative. So maybe you can talk about what some of the problems that relate to that and maybe what some alternatives might be.
Right. Well, I touched on some of this a bit already, but one of them is when you add somebody, a child or somebody else, to your real estate title or to your bank account, if they have access to the property, and usually they will have some access to the property, then the issue, especially if it's a parent and a child, the issue is going to be, well, has a gift been made?
Mm-hmm.
And again, you can look to the intention of the parties if they're around to talk to, but there's always going to be that issue of a gift. Mm-hmm. And to what extent was that what you intended to do, and to what extent were you intending to leave out other people? The other big problem with joint tenancy titling is a lot of times people will do it as a way of avoiding probate, like we talked about before, so they're just trying to get the property to the next generation. But they make that mistake about the order of death. Mm-hmm. And so if, in fact, the younger person dies first, you haven't accomplished anything. You're right back where you were before. You still own the entire property, except now the person may be significantly older and there may be less of an opportunity to do things right. Mm-hmm. So obviously, I think an estate plan, like a will or a trust, is a better option because it takes care of all these circumstances that could come up.
All right. And there are alternatives. If you want a child to have signature authority, you can have a power of attorney, or
well, you can just have them on your account. If it's just a matter of being able to write checks to pay the utility bills, they don't have to be a joint tenant to do that. They just have to have signature authority on an account. Mm-hmm. So you might have a bill-paying account, not all of your assets, but a bill-paying account that they could write checks on. So if you're unable to do so or whatever, or you just don't want to do it anymore, they can do it without any complication. Mm-hmm. There's other problems with having people on title that people don't think about, and that would be things like liability exposure.
Right. Okay.
Because you add a child to your account and they have a bankruptcy or a divorce or a traffic accident and there's exposure to liability, and you have, in effect, put your property in that mix because they have their name on title to that asset. So if there's discovery about what does this person own in a lawsuit, it's going to be including your house or your bank account. And the other thing I've seen happen over my time is people set up these joint accounts and then they have a falling out, and the parent wants the child to get off and they won't do it. And that hopefully doesn't happen very often, but I've seen it happen. And then sometimes you end up in court fighting about that.
Right. And as we said, I mean, we could even just have an argument after mom or dad passes away, child succeeds to that account, and now they're in conflict with brothers and sisters, especially if they say, well, I'm the joint tenant.
Right. That's certainly,
mine.
It does happen. And there are even things that happen that are more complex than that, that you don't expect, like the child and the parent were in the same car, and the actual child dies 2 days later, and now the spouse of the child is the successor to the bank account because it went from the child to the spouse. More complicated. So these things aren't really, to my thinking, planning or solutions. They're just, you do it and you hope that it works.
Yeah. All right. Well, how about this issue of community property? Can a husband or a wife accidentally transmute or change separate property to community property? And what would be the consequences if something like that happened?
Well, yeah, it can actually be fairly simple to do that. When you're married, there are certain assumptions about the status of your property. So if you had a premarital agreement, for example, you could avoid some of that. But most people don't have premarital agreements. So if they bring some property into a marriage, for example, and it's separate property, and just simply by adding it to a community account where they commingle their community and separate funds, they've made it community property. By making a promise, especially in writing, you can have this, it'll be community property. It's that simple. With real estate, it's a little more complicated. But still, it can be done. So conduct, how you conduct yourself, the things you say, the way you take title to assets. Again, if then it's a refinancing context, you can take separate property and accidentally transmute it just by a refinancing arrangement. And then just lacking care in how you title things. So for example, you do a living trust, and you put all your assets in the community into the living trust, but you don't define it as separate or community, and you have co-trustees. You could potentially transmute that way by having it in a trust where you're both the trustors of the trust and the trustees. So you'd want to keep track of, if you want to maintain separate property, you want to keep track of what's separate and what's community.
Yeah. Okay. So another thing as tax people that we're concerned about is this business of tax basis. So tax basis is the cost that we use to determine what the gain or loss is when we sell something on an income tax return. What are some concerns related to tax basis when we're talking about, for example, joint tenancy and community property?
Well, one of the biggest concerns these days is what Congress might do in terms of basis adjustment.
Of course. Okay.
We're kind of all up in the air about what's going to happen next. But the present status of the law is that when a person passes away, the property that they owned gets if it's a property that has basis, like real estate or stock or something, that it gets a new adjusted basis, which is the fair market value as of the date of death. So that's one of the things you do when a person passes away, is you have all of these things that have basis appraised or valued as of the date of death, so you know what the new basis is, and then from there you carry it forward for depreciation or for gain on sale purposes. But if you don't treat the property correctly, so let's say, for example, it's a husband and wife, again, we're talking about community property with a full step-up in basis. If it's an individual who dies, it's going to get a stepped-up basis. But if it's a husband and wife and they own the property together as community property, as long as they treat it as community property, it will get a full step-up in basis. But if they have it titled in joint tenancy, like many spouses in California do, and at the first death, the survivor just records an affidavit death of joint tenant, which is a really standard form, they can, because they treated it as joint tenancy property and not as community property, even though it probably was, they could lose the step-up in basis on the survivor's half. So you don't have the same tax benefit or tax consequences if you're not careful with that.
Right. Now, sometimes this can work in your favor and sometimes not. So what we've seen, for example, if somebody had a value of a property go down, then maybe you don't want the double step up. But for an awful lot of people, especially if they had property a long time,
Right.
so I bought my home in 1978 for $100,000 and maybe worth,
Hopefully it's worth more than that today.
it is. It's probably worth 600,000 or 700,000, I'm guessing.
Yeah.
So anyway, but it's a significant difference,
Right.
and so it's important to my wife and to me to be sure that we get that double
Right.
step up.
Well, it's something to be careful about. It does certainly vary from place to place because values have gone down significantly
Right.
in some places, but you need to be aware.
At least know what you're dealing with. Now, the other thing is that related to this is that when people buy a home, it's almost like default. The title company or whoever is directing it, they'll almost automatically tend to write these as joint tenancy. At least they have in the past.
For spouses, for husbands
Yeah,
and
for
wives.
husbands and wives.
Yeah. Yeah, I think that's gotten a little better. I think title companies are a little more cognizant of asking people how they want to hold title.
I think part of this business of the change, with the right of survivorship, that was sort of in response to some of their concerns.
Right.
Okay. Are there legal issues for spouses holding property as community property versus joint tenancy? I'm sorry. So I guess specifically what I'm trying to get is if somebody wants to try to unilaterally sever.
Right. Well, there are differences, and you mentioned the title companies have traditionally wanted to lean toward joint tenancy. The reason for that was, I think the primary reason for it was that even married people have the right to leave their half of the community to anybody they want.
Right.
There isn't an automatic to the spouse. If you have an estate plan and it says you leave part of your interest in the estate to children or somebody, then you're allowed to do that. Whereas if the joint tenancy property, it isn't going to pass by community property, it would pass by right of survivorship. So the community property was considered to be a little bit of an exposure as far as who might get the property.
Right.
But the joint tenancy title has a slightly different issue with the joint tenancy with right of survivorship, and that is that one owner could attempt to sever the joint tenancy by doing some documents that eliminated the joint tenancy title. So there's a danger of some unilateral activity that you don't necessarily know about that is going to eliminate the joint right of survivorship. Mm-hmm. So yes, there are legal issues with any of these forms of holding title, and the difference between community property and joint tenancy is going to be a difference for married couples.
Right. So you could have the situation where somebody has a second marriage and then they take title to, let's say, to a residence as joint tenants, and their spouse wants to be sure that their share goes to their kids. They could try to sever the joint tenancy so that then they have a separate interest from that point,
Right.
and be able to leave it to their kids. And that may not be a happy household
Right.
after that. Okay. I guess an important point that we really need to cover related to this relates to trusts, family partnerships, things like that. So what are some title problems that we see related to these entities?
The main problem, again, I see is people not doing the titling correctly. They fail to do things correctly. They fail to fund
We're not doing
things.
anything.
Yeah, they'll have a trust, but they don't fund it. They'll have a partnership,
Yeah.
they don't fund it. As a CPA, I'm sure you see people who have partnerships, but they don't have the property titled correctly. Mm-hmm. You have these boiler room operations, these what I call trust mills that get people into these things, but don't really take care of the details. So those kind of things, I think, are the main problems I see. It's just things aren't followed through with it. If you're going to do something, you should finish it.
Yeah. So take care of those details to make sure, and at least you want to have for a trust, there's a document that should be included that says, maybe as an interim, that our intention is that our home is going to be in that trust.
Right. You can do that.
Okay. we only have a couple minutes left, but maybe you can comment for a moment about some property tax things related to change in title.
Yeah, this is sort of important. Anytime you record a document in California, you're going to have an issue of whether or not the property taxes are going to change. And so there's something called a P-Corp that gets filed as a preliminary change of ownership report. So any change of ownership can result in a change in the assessment. There are all kinds of exemptions to that or exclusions from that. And so, transfers between spouses, parents to children, children to parents, transfers that are just refinancing, there's all different kinds of reasons why that doesn't apply. So you have to be sure that you get those things filled out correctly and get them filed with the recorder's office when you record any document. There also are issues pertaining to transfer tax, not change of ownership for real, but transfer taxes. And those also have exemptions or exclusions that you need to look at. And then the other tax issue you want to be careful about is if you're transferring your home to a trust or anything, that you get continue to get the homeowner's exemption. So there are boxes to check and things to fill out to make sure that happens. But if you fail to do these things, you can actually end up with an increase in your property tax that you didn't expect. So
Right. So
sometimes it can't be avoided. It depends on the transfer. But.
So sometimes there's kind of short fuses on these things where, these forms are required to be filed in a short time, and you may be able to correct it later, but you can't correct it retroactively. So you still have to pay this higher bill.
Right.
Okay. Well, I think we're just about out of time. So anyway, I hope people have a little more appreciation for the title. It seems like a small thing, that we go through. It's just a little line on a form.
Well, conveyancing is actually fairly complicated, and even sometimes lawyers don't get it exactly right, so it's that complicated. So you should get advice. You shouldn't try to do these things on your own. That would be the main message I would want to get out there for people.
Okay. Well, folks, we hope we've given you something to think about. Bill, thank you for being a guest.
My pleasure.
And we'll see you next time on Financial Insider Weekly.